So the first thing that happens when I go to court on a personal injury case is that I have to tell a lie to the jury. First thing. Almost every case I've ever had when I was selecting a jury in a personal injury case, I would say 9 times out of 10, some juror says, I have a question, isn't there insurance to cover this? And I'm not allowed to answer that question because the legal rationale behind it is not to inflate an award, so that an award shouldn't artificially be higher because the jury thinks, well, it's just some nameless, faceless insurance company will award more than is worth. So the intent is to prevent that from happening. The problem is it sort of reverberated back the other way too far. And too often juries are not compensating people appropriately because they're under the belief that the individual defendant may have to pay it. And that belief is brought out by the fact that nobody mentions ever all along the way that it's any different. So they never get any guidance on that issue. If they had this conversation that we're having right now, that, hey, this is your job, this is the way it's supposed to be done, and it came from a judge, not a litigant, and don't consider whether there's insurance or not because it's not relevant to you, then people would go in the jury room probably and say, hey, listen, the judge told us. Whether there is or isn't insurance doesn't matter. Let's just compensate the person appropriately for whatever it is.